SJC-12094, Commonwealth versus James Rutherford.
Good morning, Your Honors. Jennifer O'Brien for the defendant on appeal, James Rutherford.
Good morning.
As you know, this is a direct appeal on a first-degree murder. The defendant is arguing improper closing argument by the prosecutor and the improper introduction of prior bad acts on the defendant, against the defendant. With respect to the first argument, Your Honor, this closing argument, we would argue it was over and above what was necessary and what is permissible for a prosecutor to argue. And the first example of that is with respect to the prosecutor's attack of the defense's only expert witness, which was essentially the defendant's only defense, which was a diminished capacity type of defense. And here he had Dr. Salah testify on his behalf that at the time he had just lost his cousin to a suicide, and it had turned from bereavement to clinical depression. He began using drugs to cope, and he was in this vicious cycle, if you will, of using drugs, withdrawing from drugs, and he used crack cocaine immediately prior to this crime. So this really was the heart of the defense for the defendant, and he called Dr. Salah, I'm paraphrasing, he needs to get out of Harvard Medical School, stop writing papers, stop flying around the world, and become a human being so he can find out.
Can you go back and tell me, was there any evidence with regard to Dr. Salah's prior background which elicited this?
Well, he testified about his credentials, obviously. He had to qualify him as an expert. He testified that, he is a doctor in other countries as well as the United States, that, he's written certain things. But to call him not even a human being twice, I think, is a personal attack on Dr. Salah and completely unnecessary.
Well, that's certainly for sure, but and I'm not excusing once, but I didn't see it twice.
Yes, he first said Dr. Salah needs to get out of Harvard. He needs to get out of his office, stop flying around the world writing papers, and needs to become a human being so he can figure out what facts really count. And then he went on further to say, think of the autopsy. How many stab wounds is it? And that's evidence, real physical evidence, not sitting alone writing papers at the Harvard Medical School, real evidence, real facts that human beings rely on to make their decision about what makes sense. So
I didn't take that second argument that way at all. I took it as meaning real evidence means physical evidence as opposed to an opinion, both of which are equally admissible.
yes.
The first comment is inexcusable. The second one in context doesn't seem to be attacking him.
Well, I think if you look at the first one where he says he's not a human being and then says this is the evidence that real human beings rely on, where he's just called Dr. Salah not a human, I think you can put them together, and I think what he was trying to say is the same thing, that he's not a real...
But there was no objection to this.
This was the only thing that was not objected to. I agree, Your Honor. And my argument that it went to the heart of the defense, obviously. So by calling, it's one thing even to call him not a human being, so that's an insult on Dr. Salah, but to say that his testimony should be disregarded because it's not physical evidence. I mean, he's essentially saying, this is real evidence. Look at the photographs, look at what we have here. This testimony, that's not real evidence. That's just, Dr. Salah saying something. And I think it's quite one thing to say that the evidence isn't credible, but enough to say you should ignore this evidence because it's not physical evidence. As you know, testimony is on equal par with physical evidence. One isn't more important than the other. I do agree there was no objection. There was no instruction because there wasn't an objection. So maybe that in and of itself wouldn't be enough to save the day for the defendant. But here we go further. The prosecutor's closing argument continues, and he's talking about the television set that the defendant gave to Hernandez. you know, what was the value of the victim lying dead in the house? $500. How much, you know, essentially arguing that the value of the decedent's life to the defendant was only $500. First of all, it wasn't for $500. There were other things that were stolen and taken from the house.
There was a reference to cash being taken, but I didn't see in the briefs the amount of the cash.
It was $1,200 that they retrieved from the safe, I believe. I don't know if that's in the record.
Didn't somebody have $500 on them?
$500 was for the television. He was selling the stolen TV to his ex-girlfriend Hernandez, or his friend. So
Back, though, to the point about the real evidence, and just take a look at that in context. Can't tell the jury to disregard evidence because it's not physical evidence. And if I were to take that argument that way, it would be concerning. It seems to be that the prosecutor is referencing the physical evidence, the stab wounds, the physical evidence, and contrasting it with the background of the expert that I assume was part of the cross-examination from the Commonwealth.
yes, Your Honor. I mean, obviously, it's your interpretation can be different from mine. The way I read that is this evidence is more important. I mean, than the testimony of the Commonwealth, of the defense expert. He's sitting alone writing papers at the Harvard Medical School. So what he says here.
Is a prosecutor allowed to argue that if you have expert testimony, psychiatric testimony that's theoretical, as it often is, that the jury is capable of disregarding it and using their common sense and looking at the physical evidence of, say, premeditation, et cetera?
Yes, they can argue that one should be given more weight than the other. But where he's saying, sitting alone, that's not real evidence. I mean, he says real evidence, real facts.
If a defense expert, for example, were to testify that someone was completely incapable of premeditating because of mental illness, and that was their opinion, and there was evidence that the person conducted surveillance of the person, bought a gun, the rest, the prosecutor could certainly argue, well, look at that evidence. It belies what the expert had to say. That's proper, right?
Absolutely, absolutely. But I think in the context of saying he's not a human being, he's just sitting in an office, and look, you have this physical evidence, listen to this, not that, because I think it implies, if not directly suggests, that that's not real evidence. He's just,
That's not what it says. Again, that's not, he needs to become a human being. There's absolutely no excuse for anybody saying that in a closing argument. But when you get back, this is 3 paragraphs later.
Yes.
He doesn't say that's not real evidence. It's not a fair characterization. He says that's not real physical evidence. That's what he says.
He doesn't say that's not real evidence, Your Honor, but I think that's evidence, real physical evidence, that real facts that human beings can rely on. I guess I'm interpreting a different way than Your Honor, but I would suggest that's exactly what the prosecutor was arguing. As far as the value of the victim's life, I mean, I think the Commonwealth concedes in their brief that it was inartfully phrased. You're not allowed to suggest that the victim's life was only worth a certain amount of value.
I assume that the Commonwealth cross-examined the witness on the merits of his testimony, right?
Are you talking about the expert?
Yes.
Yes.
So I think the jury could probably figure out that maybe this is hyperbole if in cross-examination he took his time and pointed out the weaknesses or defects in the witness's testimony. And this is closing argument. I mean, I think that the jury would be more inclined toward what the attack was on a substantive basis than this, wouldn't they?
Well, Your Honor, if it was one statement, then you could chalk it up to hyperbole, and yeah, it didn't make much of a difference. But I think if you read the parts, you know, and I know you have to read the closing argument as a whole, which you should do, obviously, but the parts which the defendant objects to on appeal, it's cumulative. There are many of them. It's not one sentence that, oh, it would have been left better to say, not to say. There's a cumulative effect here where the prosecutor makes a number of mistakes.
Did Judge Kenton Walker strike that part of the testimony about the dollar amounts? I know she struck part of it, correct?
I don't know, Your Honor. I think it did come in that it was supposed to be for $500. I think Hernandez didn't have the money at the time, and she never actually paid him the $500.
The Barney comment was hyperbole and not supported by the evidence, and I think it admittedly not.
The Barney, and there was no evidence that there were small children either. So here you just have a pattern, and that's essentially what I'm arguing by the prosecutor.
And with regard to the blood, was the blood visible to the eye that was on the TV?
There was, it just was described as a small, no, I mean, if, from the photographs that I've seen, obviously, I mean, it wasn't a bloody TV. There was a small spot on the bottom corner that they tested, but it certainly wasn't as portrayed by the prosecutor, that there was a room full of small children watching Barney around a bloody TV set. It wasn't necessary for the prosecutor to go over the top in this manner, but he did repeatedly. And if you get to the end of the closing argument, the victim's last thoughts.
Now, on that point, Judge Kenton Walker agrees with the objection.
Yes.
And I read somewhere, and this goes to Justice Graziano's question, I believe, that she said that she was going to give some sort of a curative instruction and there was inappropriate argument. Did that happen in the final instructions?
It did. What happened was the defense counsel objected that there was, it was inflammatory, and the judge agreed that it would tend to inflame. And he specifically objected to the victim's last thoughts. She agreed that it would tend to inflame, and she also, on her own, noted that there was no evidence that the blood found on the basement floor was in the shape of knee and handprints. She noted that herself. So defense counsel, asked for a mistrial. He said that the closing argument was so bad that no instruction could cure it. The judge didn't give an immediate instruction, but she did give an instruction in her, among the other arguments, the closing instructions saying that, you heard, it was a 2-line, instruction saying you've heard something about the victim's last thoughts, you're to disregard that. But with respect to the other errors, there was no specific instruction.
So
there is objection. I would argue that they're all covered except for the Dr. Salah comment, because he did object to the that it was overly. Sorry, I'm looking for the exact words, but he argued that it inflamed. Appealed to sympathy, inflaming the jury with facts throughout the entire closing, and then specifically with respect to the victim's dying thoughts. So even though...
So that covers the TV and the Barney?
Yes, it doesn't argue the Barney statement per se, but again, the whole context of the prosecutor's closing argument was an unnecessary appeal to sympathy and inflaming jurors. You do need an expert for blood pattern evidence, and there was no testimony.
I didn't think that was what it was. I mean, this isn't your typical blood spatter case, is it? I was puzzled by that.
Well, there's a lot of case law that says you need an expert, and there was, if it was testified to by any of the witnesses that it's likely that there were marks, and there was nothing that was a handprint that one could say, a layperson could say, oh yeah, that's a handprint. It was more just smudges. We don't know if the victim was dragged to where he ultimately was found, or whether he crawled, whether he walked and shuffled. I mean, there was just marks, leading to where he ended up ultimately. The statement that the victim was, saying, I've had enough, I've been beaten, I've been stabbed, I'm staring at my own ceiling and the cement around the basement of my home. I mean, he was found face down. There's obviously no evidence as to what his last thoughts were. There's case law on that says you can't ask the jurors to put themselves in a victim's position. It was over the top, Your Honor, I think.
Let's assume for the moment, I'm not saying that this will happen, but let's assume for the moment that you've persuaded us that the prosecutor acted improperly, both with regard to the closing argument and with regard to the admission of the June 29th prior bad act. You still have very powerful evidence. So why should we find, as to those matters which were objected to, prejudice, and as to those which were not, substantial likelihood?
Well, Your Honor, there's no question that this is an overwhelming case for the Commonwealth, and the defense counsel's opening argument, he admitted that the defendant did it. There's no question that he committed the crime, and the evidence proving he committed the crime was strong. But here, there was a viable diminished capacity type of defense, and I think it would be a case where it would be a murder 2 rather than a murder 1. There was a lot of evidence, enough evidence, I would argue, for jurors to find that he didn't have the specific intent for murder 1. So, we're asking that it be sent back for a new trial. It was viable. The Commonwealth argues in their brief, they point to jury questions and says that helps them, but I think the second jury question actually hurts them in that here they were considering it. It wasn't a laughable defense where, the jurors came back in an hour and said, oh, come on. They asked specifically for more information on the diminished capacity type of
I noted
defense.
that. Does that suggest that the judge's instruction used the term diminished capacity?
Well, I know diminished capacity obviously isn't recognized. In closing, I believe the defense counsel argued it as diminished capacity, and his point was this is not a lack of criminal responsibility, in explaining to jurors the difference between a diminished capacity type or mental impairment defense versus criminal responsibility. So that was, it was a viable issue, and it was unnecessary for the prosecutor.
But that language came from the prosecutor. Came from defense counsel and not from the judge in her
No,
instructions.
the judge doesn't call it diminished capacity, but I think when they're talking about it, people do refer to it as that. Just going on to my second argument, the prior bad act that was introduced, it was completely unnecessary, unrelated to the crime. And again, I'm asking the court to look at this cumulatively. Maybe this alone wouldn't be enough to save the day, but when you look at the Commonwealth's closing argument and the errors committed there, in addition to this act, cumulatively, we're asking the court to give the defendant a new trial or reduce the conviction. Here, the defendant was found...
If I can ask you about that.
Yes.
I've not seen Dr. Salah's testimony. Did he indicate that the drug use or that the events would have occurred after June 29th, such that this would negate that testimony in some fashion?
I don't think he was specifically asked about this, the June 29th.
No, I know, but was he speaking about events involving drug use and whatever else which occurred after June 29th?
Well,
Or I'm trying to think why it is, I'm trying to understand
why it was relevant.
why it was arguably relevant, and I don't know whether there's anything that Dr. Salah testified to which arguably it would be negating.
Not specifically, just that, no, the defendant in the past had lost his friend. He was, living the lifestyle of somebody abusing crack and cocaine. He was, depressed. He was sleep deprived. He was under the manipulation of Chesko, his co-defendant, not at the trial, but his girlfriend at the time. I mean, the Commonwealth says it's necessary to establish a relationship between the defendant and Chesko, but there was no question that he knew Chesko. Chesko was having his baby. There was no, here the knife that was found there was confiscated, so it definitely wasn't the murder weapon. And I had to just note that initially defense counsel was going to agree to have everything but the knife, and they thought it was a mask, but it was gloves, come into evidence. But then there was no stipulation, so at the time, he objected to all of this evidence coming in. There was a pellet gun came in. I don't know why. It's kind of beyond me as to why the police officer came in with this evidence in a bag and held up a knife and held up a pellet gun when it had nothing to do with the crime. It wasn't introduced into evidence. It was just, marked for identification. But here, it was completely unnecessary, and when weighing the probative versus the prejudicial value, it certainly had little to zero probative effect and a lot of prejudicial value.
Did the judge make any findings that it was more probative than prejudicial?
No, I mean, what she said initially was, we'll have a voir dire and see if this is relevant at all. And then it seems like a voir dire was never had. The police officer testified, there was an objection, and she seemed to concede. She said, it bothers me, it's obviously not the same nice, the relevance is bothering me, and I'm paraphrasing, I don't know why this is relevant, but I think we can still cure it by giving an instruction. And there was an instruction, during the
So she had said, we're going to do a voir dire on it,
yes, with the officer.
and then the prosecutor elicited it without saying, Your Honor, I know you want to do a voir dire on this, we should do that. The prosecutor did not make any reference to it, just went ahead and sought to offer it?
No, defense counsel said, I thought we agreed the knife was out, and the prosecutor said, oh, I could be wrong, but, this is why it's relevant, Your Honor. And she said, I think we can still save it, classify it as a prior bad act, and I'll give a prior bad act instruction with my instructions
So
at the end.
the basic point, whether the ruling was correct or not, the basic point of the evidence, pellet gun, I don't understand that, is that the defendant saying that he lacked capacity to formulate the intent necessary for first-degree murder.
Yes,
And a week before that, when he's not in the same situation, he's got the same type of weapons. He's got the same connection to
but I mean,
the girlfriend.
he's got the
And-
connection to
and
the
he's got-
girlfriend.
And he's got the gloves, if I'm remembering that.
Well,
might have been
it's
some-
unclear whether the gloves were actually confiscated. They asked the officer, if he had the other things. They said, and do you have the gloves? And he said, no, not with me. So I don't know, it's unclear whether he actually took them, so these could have not even been the
Well,
same
you don't need
gloves
the
that they found
physical evidence
thereafter.
to refer that that he had gloves earlier.
That
I'm not trying to say that the probative value and undue prejudice means that it should be admissible, but it's not a surprise what the theory of admissibility was, that this rebuts the claim that the defendant lacked the capacity to formulate the intent at the time of the killing by looking at what his intent was a week earlier.
Well, the
That's
fact
rub.
that he carried a knife or carried gloves with him and he was crouched in a parking lot, he's not,
It's a fair point. I agree with you. It's a very fair point, but it's not a mystery what the theory of admissibility was. Whether it should have been admitted or not is a good question.
I don't know how it would go to his mental capacity, Your Honor, just that he's crouched in a parking lot. We don't know that he was planning to use the knife for something. I mean, it was all speculative and open for the jury. Was he waiting to jump somebody? Had he just committed a crime, or is he just crazy and likes knives? I mean,
It's a reasonable point.
it doesn't make any sense, Your Honor. I see I'm out of time. Thank you very much for your time.
Good morning, Ms. Lazarmborough.
Good morning, Ellen Lazar-Moore for the Commonwealth. The Commonwealth asked this court to affirm the defendant's conviction. First, because the prosecutor's closing argument, taken in context, was a proper comment on an expert witness's credibility and proper comment upon the evidence and reasonable inferences from the evidence.
You don't think it was a little over the top to say he wasn't a real human being?
I certainly think that he could have chosen his words more carefully, but I think that in context, when you view that entire argument after the cross-examination of Dr., I believe he pronounces it, Saleh, there were at least 15 pages of questions on cross about all of the factors that the doctor seemed to have ignored. And so I think the thrust of the argument was that the jury should use their common sense and should disregard the doctor's opinion because the doctor had seemingly ignored very sort of common sense indicators that the defendant did in fact have the ability to intend the crimes and did
That's a
intend them.
fair point, but to do it the way that the prosecutor did it, to imply that he's out of touch with reality, he's not a human being, he should be an ordinary person, even elitism there, referring to Harvard, as if he's trying to tap into some anti-intellectualism, and that's what this defense was all about. So that's pretty bad, isn't it?
Well, I think, Your Honor, to some degree, that piece of it about Harvard Medical School was a response to the defendant's argument. There was a lot of testimony on when the defendant presented Dr. Saleh on direct about his credentials, and then in his closing, defense counsel argued he's done 500-plus cases, he works for judges, he presents to Superior Court judges, appeals court judges, federal court judges, he teaches at Harvard Medical School, Harvard Law School, nationally, internationally renowned, impeccable credentials, amazing gifted student, a brilliant man. He's going to put all of that on the line for this. So I think to some extent the references to Harvard Medical School were a response to that. I don't claim that that's the way that the prosecutor should have responded, but I think that when the whole thing is viewed in context, the jury certainly would not have thought the prosecutor was suggesting that the doctor was not a human being. He was saying he's ignoring the factors that you, as people with common sense, could see matter in making an assessment of the defendant's mental state, and then he specifically discussed what some of those factors were. He talked about the fact that the defendant admitted that, he went there, he first stabbed the victim to intimidate him, to get him to open the safe. They had duct taped him, tied him up with duct tape. They either pushed him or let him fall down the stairs to the basement, and then they completed the robbery, and then when it was all done, then the defendant went down there and stabbed him again to kill him, to minimize his chances of being caught. And the defendant had admitted these things to Dr. Saleh, and the doctor apparently seemed to sort of ignore them in reaching his opinion. And I think it would have been clear to the jury that that was the thrust of the argument, that look at all of this evidence that he's ignoring, and you should ignore the doctor's opinion because it's not credible in the face of all of this evidence.
That's all very reasonable. You can attack the credibility, you can attack the basis for the opinion, you can suggest that there's a bias, but when you say somebody's not a real human being, you're not attacking the opinion, you're not attacking the basis for the opinion, you're impugning the person, and that just doesn't fit into a closing argument. You're impugning that person's identity, individuality. I'm not a real human being. I don't see how you can do that in a closing argument.
Yes, Your Honor, and as I said, I'm certainly not trying to defend that choice of words. If I could tell the prosecutor now to have done it differently, I certainly would. And so I don't say that saying he needs to become a real human being was appropriate, but I just think that if we're looking at what the effect upon the jury would have been, that the jury would have understood the meaning of the argument. The jury would not have thought the prosecutor was claiming that the doctor was not human. And there are cases that recognize that at a certain point, the argument is so sort of sarcastic or hyperbolic that the jury would just take it with a grain of salt, understanding that this is argument, understanding that there were many, many pages of tough cross-examination on this very topic, on the fact that the doctor seemed to have ignored these what seemed to be clear indicators of intent, and so that the jury would have understood. And of course, the judge gave, instructions about the purposes of closing argument repeatedly, about the jury not being affected by sympathy or swept away from calm, clear judgment. And the jury's verdict, I think, supports that the jury were not swept away by what the defendant claims are multiple appeals to sympathy, because they convicted the defendant based on deliberate premeditation and felony murder, but not extreme atrocity or cruelty. And if you look at the factors supporting a verdict of extreme atrocity or cruelty, of course, those all go to the victim's suffering and the defendant's either taking pleasure in or being indifferent to the victim's suffering, and all the things that I would think would that a jury being swept away by sympathy for the victim would say, oh, absolutely, those factors are here.
Well, with regard
But
to
they
that, with
didn't.
regard to that, apparently one of the jury's questions was it the defendant's or the victim's conscious pain and suffering that mattered?
Yes.
Meaning that they may arguably have been confused between the extreme atrocity or cruelty and the defense argument that the defendant was suffering from the suicide of a friend or of a relative?
I
How'd the
believe
jury
so. It was.
How'd the judge respond to that?
The judge just responded that it was the victims, that they were to consider whether the victim had suffered, that those factors applied to the victim, not the defendant. And I believe she may have just sent it back in writing. I don't think she brought them in to re-instruct. I know that counsel referenced the fact that I argued that I also think that the jury's questions showed that they were not swept away by any appeal to sympathy, because it showed that they didn't just go into the jury room and say, oh my God, this was horrible, check, check, check. They went through the elements. They were considering the defense. They did ask for instruction on what is this diminished capacity thing that the defense counsel repeatedly referred to in his closing argument. And so the judge then brought them back and gave them an instruction on the fact that anywhere where the Commonwealth is required to prove intent or knowledge, the jury can consider whether the defendant's ability to form intent or have knowledge was affected either by a mental condition or intoxication. And so that question clearly showed that the jury was considering the issues in the case and didn't just rush to judgment based upon, being swept away by sympathy for the victim.
What was the theory of admissibility on the uncharged misconduct?
So there were several different items. As to the purse that had Leanne Chesko's license in it, the prosecutor clearly argued that it was to show the connection between the defendant and his co-defendant. And even though the defendant is saying, well, they didn't need that, we admitted that there was a link to Chesko. But I don't think the necessity of the evidence is the standard for relevance. Clearly, the Commonwealth can still put that proof in, even if the defendant isn't disputing the connection to Chesko. As to the gloves, it was that after the crime in the storage space with all of the stolen items, there were black gloves found that tested presumptively positive for blood. And the defendant, 6 days before the crime, was found with black gloves. As to the knife, the judge found that she did think it was relevant to state of mind because 6 days before the crime, when the defendant was... So the defense
But
was...
that's not
I'm
the
sorry,
end of the inquiry, though. I mean, okay, it's relevant, but
Yes.
should it come in?
Well, the judge did not explicitly make a ruling about whether she found it
Didn't even
more...
consider the prejudice, did she?
I'm trying to recall, I don't believe the defendant explicitly argued about whether it was more prejudicial than probative. I know that the judge did not make an explicit ruling about whether it was more prejudicial than probative. She did believe that it was relevant to the defendant's state of mind, and she said, and he has raised his state of mind, the evidence, the defense, was that this was long-standing depressive disorder, drug addiction, sleep deprivation, and coercion by Leanne Chesko. And then 6 days earlier, he's found with this knife. He doesn't seem to be delusional or under the effects of any of this, and he's saying, well, I'm carrying this because I have trouble with people on the streets. I recognize that it's...
The inference, I mean, first of all, the possession of the knife and the possession of, and his relationship to Chesko was not a reason offered by the prosecutor for its admission. The prosecutor offered it only for state of mind, and it was admitted only for state of mind. So how can you argue that it's admissible on grounds that the prosecutor did not claim it's admissible and that the judge did not tell the jury it was admissible for?
In the written motion in limine to admit the evidence, the prosecutor argued that the purse with Chesko's license in it showed the connection to Chesko. When the evidence came in and the defendant objected, it was only, she only limited consideration of the knife and the pellet gun to state of mind, not the purse or the gloves.
And how is that relevant to state of mind? How is the fact that
knife.
he had Jesco's wallet and that he was carrying a knife relevant to his state of mind on July 6th?
So again, Your Honor, she did not limit the consideration of Chesko's, possession of Chesko's license to state of mind. That came in for all purposes, and as I said,
I thought she spoke about the prior bad act, which you claim is not a prior bad act, but we'll get to that in a moment, and said you may consider it only for state of mind.
I believe that she only said you may consider his possession of a pellet gun and a knife as proof of his state of mind, not that he committed this crime, not that it was propensity evidence. It's on transcript 4, 85 and 86 is right after the evidence came in, and then again during the final charge at transcript
So
7.
alleged misconduct such as having a pellet gun. So would this not fall into the alleged misconduct? This whole June 29th thing?
Well, Your Honor, I don't believe that the defendant having gloves or his girlfriend's driver's license are misconduct. I don't believe that those are prior bad acts. So when the judge says alleged misconduct, and again, she explicitly refers in both of her limiting instructions only to, she does say such as having a pellet gun and a knife.
Okay.
But she doesn't refer to the gloves or the license.
Okay, so tell me why this goes to state of mind on July 6th, which is the relevant time period. Because he possessed a knife on June 29th,
because
and because he had her wallet on June 20, or because he possessed a knife, that goes to his state of mind on July 6th.
Because his claim was that on the day of the crime, he armed himself with a knife, went to the victim's home, robbed him, stabbed him, did everything he did because he was under the effects of this alleged mental condition, that he had this depressive disorder, that it was drug abuse and drug withdrawal, that it was sleep deprivation, that it was pressure from Chesko. And so the argument was that 6 days earlier, he's found armed with a knife, but he's giving the police a different reason why he has it. He's saying, I have problems with people on the street. And the judge found that she agreed that that was relevant to his state of mind. There's no evidence that 6 days earlier he's under the influence of any of these factors that he claims caused him to commit the crime, but without the requisite intent.
Well, presumably he was under the continuing influence of the depression, was he not? That would have not been something that cropped up just a week later. Wasn't the argument that he had been depressed ever since his friend committed suicide?
Yes, that was his argument. But
It's an inconsistent statement with what Dr. Soleil or he said about obtaining a weapon, correct?
yes, that it went to rebutting why he claimed he did what he did, the factors that were causing him to do it, and then 6 days earlier, he's arming himself with a knife for different reasons. But if the court were to find that it should not have been admitted, there was no prejudicial error. First, because the judge did strictly limit it to consideration of state of mind, and if the jury were to find that it was not relevant to that, then they would not have considered it for any other bad purpose. The knife and the pellet gun themselves were not admitted as exhibits. They didn't go back in the jury room. The prosecutor did not mention this at all in closing argument. This was essentially 2 pages of transcript out of a 7 or an 8-day trial. So, and also given the judge's overall instructions about the Commonwealth's burden of proof and no bias, sympathy, prejudice, what the jury could consider, and also the strength of the evidence, which in the Commonwealth's opinion was overwhelming. There was overwhelming evidence that he planned this robbery. He, before the robbery, secured a place where he could store the stolen items. He asked a friend to help him. He went to the house, scouted out the property. He then went back, armed with at least one weapon, snuck in, it seems, through cutting open a window screen, stabbed the victim, he said, admittedly, to intimidate him, to get him to open the safe, duct taped him, pushed him down the stairs or let him fall, and then went down later after it was all done to kill him to minimize the chances of being caught, and then went and brought all the materials to this storage facility that he had obtained. So I think the evidence of his ability and his actual intent were overwhelming, and that this one minor piece of evidence that no one drew the jury's attention to after it was over would not have had any undue prejudicial effect.
One last question.
Yes.
Page 8 of your brief. There was expert testimony that the sneaker print, there was a 1 in $683 billion chance that it was random? From a sneaker print? Where did that come from?
Yes, I think my memory is they had an expert who testified on the shoe prints, and so there was testimony about sort of the general characteristics of a Converse shoe that has this pattern on the bottom, and then the particular characteristics of this shoe, if it had, let's say, a cut in the bottom or a rock stuck in it, or and so they statistically calculated that the likelihood of any other Converse shoe of this size with this pattern having made this shoe print was 1 in 683 billion. I don't know if they gave the basis for how they came to that number, and I don't
Was there
think
any
it was
objection to that?
challenged by the
No.
defendant.
Okay, I know for DNA testimony, but there's a reason why you can do it for DNA testimony.
Yes.
I have not seen it with regard to Converse shoes.
No, but I don't think there was any challenge to that evidence.
Okay,
If
thank
the
you.
court has no further questions, I'd rest on my brief. Thank you.
Thank you.